Hi, I'm Mike Thompson. I'm here to talk to you today about SB 93, California's new right to recall law for certain hospitality employees. SB 93 was signed into law on April 16, 2021, and what we're going to talk about today is what employers are covered by SB 93, what employees are potentially subject to recall, and what procedures do you have to go through for those employees. SB 93 is targeted to various segments of the hospitality industry, and it includes hotels with 50 or more rooms, private clubs with 50 or more rooms, event centers of a certain size, which includes arenas, concert halls, convention centers, lots of businesses that operate out of airports, including hospitality, building services that provide janitorial, maintenance, or security services to office, retail, or commercial spaces, and then also subleasees of hotels and event centers. So a restaurant that leases space out of a hotel may also be covered by SB 93. So former employees have rights under SB 93 if they meet two criteria. One, they had to work at least 6 months in the year 2019, and two, their job loss had to be tied in some way to COVID-19. Now that could be that a public health order caused them to lose their job, or simply the downturn of business as a result of the COVID-19 pandemic forced the business to lay them off. If they meet those criteria and they work for the eligible business, then they have these recall rights that SB 93 creates. So if you're an employer subject to SB 93, what do you have to do? Well, if you have a job that becomes available within 5 business days, you need to make a written offer of the job to the laid off employee if the employee is qualified. And they would be qualified for the job if their prior job was similar or the same as that job. Now, what if you got multiple former employees who would be qualified under SB 93? Well, you have to provide it in order of seniority. And what you can do is you can make conditional offers to all of the qualified laid off employees and then make the final offer to the employee who accepts with the most seniority. Now, if you decline to recall an employee on the basis that they're not qualified, there are certain requirements you have to do, including you have to give written notice to the employee within 30 days, setting forth certain information, including the reasons for the non-recall. Of course, there are record-keeping requirements with SB 93. Employers have to keep for 3 years after the notice information about the employee, as well as copies of the notice and then copies of any communications or correspondence with the employee. SB 93 also prohibits employers from retaliating against employees who exercise or assert their rights under SB 93. Now, SB 93 provides the Labor Commissioner with a lot of mechanisms to enforce the new law. The Labor Commissioner can order the hiring or reinstatement of employees and can award them front pay, back pay, and lost benefits. The Labor Commissioner can also issue civil penalties of $100 per employee plus liquidated damages of $500 per employee per day, not just against the organization, but also against executives who violate SB 93. So the foregoing is a great high-level view of SB 93, but of course the law's got a lot of details and a lot of nuance, and as it packs a very big punch, employers who might be subject to SB 93, we really want to make sure that they get appropriate legal counsel and that they implement the provisions of the new law. One last thing, I almost forgot, SB 93 does require you to press that subscribe button. I don't write the laws, I'm just telling you what's in it. Until next time, I'll see you later.